Hi everyone, today's session is Learning Outcome 2 on Equity and Trust, and my name is Shazia Khan. So today we'll be going through Learning Outcome 2, which is to understand the requirements for the creation of valid trusts. Before I do that, I want to give you a summary of what we did in the last session, which was Learning Outcome 1, which was to understand the historical events leading to the development and nature of equity. So in Learning Outcome 1, the whole point was to try to equip learners into understanding the principles governing the law of equity and trust. We looked at applying equitable rules to facts-based scenarios. We also looked at, first we started off with the different types of law within the UK. Things like constitutional law, administrative law, civil, criminal, procedural and substantive. We then went on to look at what equity is in the context of law, in regards to what the legal definition of equity is. And we looked at the example of equity law. We also looked at what the principle of equity is with reference to the historical elements. We went on to look at what common law is and how it's a body of English law which originated historically in the tribal justice in England thousands of years ago. We looked at the importance of the law of trust within the UK and why this was created. We looked at English trust law, and we looked at the Judicature Act 1873 and the importance of that act with reference to common law and equity. We then went on to look at 1.1, which was to explain key historical events leading to the development of equity. And we looked at how common law came about and then equity was implemented and how they work together as well. But we also looked at why equity was brought about. We looked at historical background before the Norman Conquest, so from the 8th to the 11th centuries, or so like over 400 years period. We looked at the key dates, we looked at the significance and the importance of the Earl of Oxford case, why that was important in regards to common law and equity, and why that was introduced with reference to examples. We also looked at another example, which was the case of G and Pritchard in regards to equity and trust. We also looked at the fusion of equity and common law with reference again to the Judicature Act. We then went on to look at the relationship between law and equity, which was assessment criteria 1.2, and how there were 5 stages of equity that needed to be taken into account. We looked at the meaning of equity, how it's to do with fairness, how it's to do with body of rules in regard to equitable, equitable right or a claim. We looked at the relationship between common law and equity, and that is quite a big thing because it identifies that they work together alongside each other. We then went on to look at the differences in remedies. So when addressing common law, how it was just the remedy available was monetary compensation, whereas when equity was developed, there was rescission, injunctions, rectification, so there were more remedies brought around. So we then went on to look at the basic distinction between both common law and equity, and why there was a need for equity to be brought about, and the main reason was to do with the amount of remedies at that time. We then went on to look at assessment criteria 1.3, which is to explain the meaning of equitable maxims. We looked at some of the maxims in regards to equity. So firstly, we looked at equity sees that has done what ought to be done. and explained that judges look at this from the enforceable side, and situation would be had in if the contract been completed. We also looked at another maxim, which was equity will not suffer a wrong to be done without a remedy, and how the maxim was developed as common law, had no new remedies, only monetary damages. We also looked at equality is equity, where one person involved in owning a property, the courts prefer to divide property equally. We then went on to look at how one who seeks equity must do equity, and how, and then another maxim, another couple that we looked at were, he who comes into equity must come with clean hands. And another one was equity follows the law, how courts will firstly apply common law, and if it's not fair, then equitable remedy will be provided. We also looked at the development of equity and common law, and why there was a distinction between both, but why there was a need to bring equity about, and looked at the requirements for this, but also looked at the fusion between equity and common law, and the referred to the Judicature Act, and the relevance of these cases in regards to common law and equity. So then we went on to looking at different key terms which were more relevant for the students, things like what a writ is, what equity is, what remedy is, so at least they have an idea of what each term means when we refer to it, even if it's a Latin phrase. Things like ire means a court held by in royal justices in medieval times. And things like assizes, people wouldn't understand that, so it's meetings with barons that issued binding decrees. So we looked at certain terms that would help the student or the learner to understand what each of these terms meant whilst going through these terms. We then finished off learning outcome 1, and now we'll be looking at learning outcome 2, which is to understand the requirements for the creation of a valid trust. So we looked at all the history around the trust, and now we're looking at the requirements for creation of trusts. So key terminology. So what is a trust? So a trust is a creation of equity, and it's easier to describe than define. So when a trust exists, the trustee is the legal owner of certain property, but is not entitled to use the property however they wish. The trustees hold the property for the benefit of one or more beneficiaries. The organisation of a trust is straightforward. A trust provides assets for the benefit of the beneficiaries. So a family trust is simply any trust vehicle you set up for the benefit of your family members. The person who creates it is a guarantor, who's also called a trustor or the settler, and the guarantor establishes the trusts and places assets into trust. These assets become trust property. A trustee controls the trust assets, and a trustee ensures that they get turned over to the recipients, which are referred to as the beneficiaries or heirs with entitlement to the trust assets. Like a will, a trust is a way to distribute an inheritance. In some ways, a trust is more straightforward than a will. For example, the guarantor legally transfers property to the trust rather than directly to the beneficiaries. This makes legal challenges and conflicts between family members over inheritance less likely. With a trust, keeping each person's inheritance details private is also possible. The beneficiaries do not know what the other heirs received. So it's really important in that instance, so at least it doesn't cause any sort of family rifts or any sort of controversies. When the trust owns the assets, probate is unnecessary when you transfer all your assets to the trust. So there's no point of going through probate at that time. So what are the different types of trusts? We have fixed trusts and discretionary trusts are two types of trust. So you've got fixed and discretionary. In a fixed trust, the size of beneficiaries' interest is known from the time the trust comes into being. So the fixed trust identifies the beneficiary or beneficiaries A fixed trust details how to distribute the assets. The trustee still oversees the distribution, but they cannot change the terms of the trust that you laid out. So as a guarantor, you provide directions about the schedule of the distribution of the trust income, the division of all assets, so who gets what from your estate, any parameters or conditions that you wish to place. Because the grantor provides the necessary details, fixed trusts do not necessarily need an individual trustee. In some cases, a financial institution can handle the distribution of assets in the trust. And there are two forms of fixed trust. You have a life interest and conditional one. The life interest one is gives you a way of determining who will inherit certain assets, whereas a conditional trust is also known as an incentive trust, and it's an agreement that puts specific rules on the distribution of the inheritance. So now we're going to go on to discretionary trust, and here the settler describes a class of potential beneficiaries and gives the trustees to discretion to select which beneficiaries to benefit and how much and by how much. So a guarantor sets up a trust but does not specify the beneficiaries in a discretionary trust, as we mentioned. A discretionary trust does not provide any guidance about the division of the estate. The trustee makes decisions about the distribution of the assets and how they want to do that. With discretionary trusts, the trustees describe the distribution of the assets. The grantor passes these decisions to the trustee, who can provide the estate as they see fit. The beneficiaries have few rights in this arrangement. They claim or demand any assets or funds from the trust. The trustee decides how to distribute the inheritance. Discretionary trusts are an option when the guarantor is concerned about their beneficiaries' ability to manage the inheritance. These trusts may also be an answer if heirs are too young or the beneficiary struggles with conditions that would make managing an estate difficult, maybe mental health issues or things like that. What are the powers in a trust? A power or mere power, on the other hand, is where only does the holder have discretion over his actions. He has discretion over whether to act in the first place. So you have an ordinary power, which creates no proprietary rights in any beneficiary. Most trusts give the trustees wide powers to appoint income to beneficiary or apply income for the benefit of the beneficiary. In the absence of specific power under Section 31 gives the trustee the power to pay income or for maintenance, education or benefit if it's a minor. So, you know, it needs to be taken into account. So, you know, the holder is under the trust power, the holder is under an obligation to appoint the property, but has the power to select who to give it to. So a trust power is imperative, but a bare or mere power is permissive only. The key question here is to ask, does the clause create an obligation to appoint? So it's really important. Creates no proprietary rights in any beneficiary, nor is the holder of the power obligated to exercise it. The holder of the power not obligated to actually perform the power, and so-called beneficiary of the power gets no equitable right in asset. An example, give trustee 1K, you may give this to any one of my students. In such a case, none of the students get equitable right in that 1K. Two forms of mere power, fiduciary and non-fiduciary power. When assessing responsibilities, it's essential to understand the difference between fiduciary and non-fiduciary roles. A fiduciary is an individual or entity with a permitted obligation to operate in the best interests of another person or an organisation. This obligation involves placing the other party's interests ahead of their own, which requires an elevated level of care and trust. So it's really an important role that you need to deal with. On the other hand, a non-fiduciary role does not carry the same responsibility. According to the law, instead, they are responsible for providing disclosure of information without attempting to influence decisions or benefit from others' losses unduly. Knowing when and how to differentiate between these entities can be crucial in effectively consuming any sort of advice or anything. A fiduciary power is the power that is held by a person who is in fiduciary position. So who's responsible for acting in someone else's interests concerning finances or investments. The person is held accountable to adhere to strict standards of care and loyalty when dealing with these matters. Non-fiduciaries, again, operate under a relaxed standard. They do not include the same responsibilities or requirements as a fiduciary relationship. An example of this can be seen in the different duties required for financial advisors. Those considered fiduciaries are legally obligated to work in the best interests of their clients, while those labelled non-fiduciaries merely aim to produce sound financial advice or services for their customers. So you can see the difference, the powers they have, fiduciary more than non-fiduciary powers. So non-fiduciary given to the person in capacity that not acting as fiduciary. So distinction, as we said, these types of fiduciary is acting in utmost good faith and is prevented from acting irrationally or anything like that. So now we're going to look at 2.1 assessment criteria, analysing the features of different types of trusts. So we've got discretionary trust, which we mentioned a little bit earlier about, between ordinary trust imposing a trustee. So you've got discretionary trust, which is like a fixed trust for which the settler does not set fixed beneficiaries or trust interests. And the trustee of discretionary trust has the power to decide whether beneficiaries will benefit from the trust. He or she has the right to decide the extent of its benefit. Fixed trust, which we referred to previously as well. Fixed trust are established form of living trust for estate planning. They enable the settler to control the money and assets for the benefit of the trust beneficiaries. Beneficiaries of a fixed trust receive trust property on a specific schedule set forth by the settler. The trustee of a fixed trust has little or no discretion to distribute trust property. He or she cannot change the beneficiary or the benefits they are set to receive. The most common type of fixed trust is a life trust, under the terms of which one individual have the right to all the trust income during his or her lifetime. On the individual's death, the property will generally be payable to named capital beneficiaries. Another type of fixed trust is one contingent upon the beneficiaries satisfying the certain conditions, such as maybe reaching a certain age. Once the express condition is satisfied, the beneficiaries will typically have an absolute interest in the capital. The settler may also choose multiple beneficiaries and provide a fixed benefit or percentage for each of his or her beneficiaries. For example, the settler may grant 70% of the trust benefits to a spouse and then 30% of the trust benefits to a child. Or the trust may be established for a handicapped child to ensure that he or she is properly cared for if the child's parents or guardians die. The trustee is bound to make a distribution to the beneficiaries in the predetermined manner as set out in the trust deed. The beneficiaries have an interest in possession under the trust, subject to a deduction of sums paid by the trustees in the exercise of their administrative management powers. So here it says who imposes the trust is a beneficiary. We don't know exactly, then we don't know who has the power to petition for court. Becomes a resulting trust. Now trustees holding benefit for settler, and if like we mentioned the example, then if they died, to my estate. So this is how it is. For example, so that T shall distribute all 1K equally to any of my grandchildren who have enrolled for a full-time uni course. T has no discretion about the amount of property to be held for each beneficiary. Rather, the trustees are obliged to act in the limited manner so described. The beneficiaries have proprietary rights in the equitable interest of the fund in accordance to the terms of the trust instrument, and this is a fixed trust for those who benefit and how much, but he can't list now. The complete list is in the case of RIC and Broadway cottages. If there are claimants about whom the trustee beneficiary could not be certain, then the trust would be void for certainty. What if the identity of the membership of the class cannot be known until an identified time in the future, which the trust is to be performed, as in the case of Swain and Law Society? Rights under Saunders and Forto is a product of this type of trust. It is possible that this may not be the case in relation to other forms of trust considered. An example is, once I create the trust, my daughter can go to trust and say she's an adult, have 100% equitable title. Daughter can go to court and get the money. Doesn't matter if the settler says she's only got the money once she graduates. In conclusion, in regards to the first part of it, for discretionary trust, it's important to have certainty of objects, so the trustee knows who to consider when deciding how to distribute the trust properly. Trust property. Originally, the test for discretionary trust was the same as for fixed trust, the complete list test. However, this caused many problems for discretionary trusts, as they're usually more potential beneficiaries for discretionary trusts compared with fixed trusts. So this led to the creation of, as some call it, the is or not test. This means that the potential beneficiary will have to show that they are fit within the description of the objects. This is easier than the complete list test because one person cannot prove they are potential beneficiary. The trust does not fail for certainty. It is just the individual who did not satisfy the requisite criteria is not entitled to be considered to receive the trust property. For fixed trust subject to a condition, the test of certainty will vary depending on whether it is condition subsequent to of a condition for a condition subsequent. That is a condition which, if it is satisfied, the beneficiary is no longer entitled to the trust property. There must be certainty as to the condition from the outset of the trust. For a condition precedent, that is a condition which must be satisfied before the property is distributed. It will be valid if it can be said that just one person satisfies the condition. If no certainty of objects can be assigned, the trustee will hold the property on trust for the settler. This is a resulting trust. This means that the settler can demand the legal title back from the trustee and then create another, this time valid trust. If the trust is testamentary, the trustee will hold the property on trust for the benefit of those entitled to residual estate of the deceased. 2.2. Apply statutory rules and their case law interpretations in appropriate scenarios. So what do we mean by statutory rules? These are rules, regulations, or bylaws under any act of Parliament. So English law, there are 3 rules that exist to assist in court. So any court would use these rules. So we have the golden, the mischief, and the literal rule. These rules are the most common in examining the meaning of language. And without these rules, the reader of statute would be able to interpret what they mean and what is meant by the law and how they would apply it. So, like we said, they're known as the literal, golden, and mischief. So, firstly, the literal rule. The literal rule takes precedent over the others because it literally what the law says. So, it identifies what the law says and why it says that. So, the literal rule is the main one. This rule is the basis of all court decisions in relation to statutes. Here, judges rely on the exact wording of the statutes for the case. They don't interpret meaning. So, a famous case in regards to this was where Lord Diplock in Tuport, Steele and Sears case 1980 defined the literal rule as where the meaning of the statutory words is plain and unambiguous. It is not for judges to invent fancied ambiguities as an excuse for failing to give effect to its plain meaning, because they consider the consequences for doing so would inexpedient or even unjust or moral. This definition actually by Lord Diplock says that a judge should not deviate from the literal meaning of the words, even if the outcome is unjust. If they do, they are creating their own version of how the case should turn out, and the will of Parliament is contradicted. So, it's really important that they follow the literal rule. And another famous case in regards to the literal rule, and here we've got the leading case of R and Harris in 1836, where statute was made an offence to stab, cut or wound another person, and Harris bit off a friend's nose in a fight and then the police officer's finger. Harris was not found guilty on the basis that the words in the statute pointed to the use of a weapon, and teeth are not considered a weapon. The literal rule is often criticised when absurd outcomes are reached, as in R and Harris, and it does not appear to be a rule against using the reader's intelligence and common sense. But if the rule did not exist, then the courts would have the power to interpret each statute as they are, effectively allowing the judge to rewrite the Act of Parliament. The literal rule also involves two subsidiary rules. The first is the nostitur associis rule, which means that for the meaning of the word must be determined by its context. For example, to read a book or to book a room. The second is estudum engerec, which means that any general term is dependent on any specific which precede it. For example, if a law refers to automobiles, trucks, tractors, and motorcycles, then the term vehicle would not include aeroplanes, since the list was of land-based transportation. Another example of the literal rule was in the case of Fisher and Bell, 1960. Under the Offensive Weapons Act of 1959, it's an offence to offer certain offensive weapons for sale. Bristol shopkeeper James Bell displayed a flick knife in his shop window. When brought to trial, it was concluded that Bell could not be convicted given the literal meaning of the statute. The law of contract states that having an item in a window is not an intention of sale, but is an invitation to treat. Given the literal meaning of the statute, Bell could not be convicted. There are many disadvantages of the literal rule. For example, another case in R and McGuinness, 1987, the defendant was charged with possession of a controlled drug with intent to supply under the Misuse of Drugs Act 1971. The defendant claimed that the drugs belonged to a friend who was picking them up later. The judge stated that handing the drugs back was supply. The case was upheld on appeal. In his speech at the appeal, Lord Keith proposed that the word supply, in its ordinary natural meaning, conveys the idea of furnishing or providing to another something which is wanted or required in order to meet the wants or requirements of that other. So, the literal rule can create loopholes in law, as we can see from the Harris case and the Fisher and Bell case as well. And it could also lead to some injustices as well. And the famous case for that is the London North Eastern Railway Berryman 1949 case, where a rail worker was killed whilst oiling a track. No stopping man had provided under statute. Compensations provided on death of workers, replacing on relaying track. The statute did not cover oiling, as so compensation wasn't given. This was undermining public confidence in the law. The next rule is the golden rule, and this can be described as a shadow of the literal rule and should be used as a backup if the literal rule provides any sort of absurdity. The golden rule was used in quite a famous case called R and Allen, where the defendant was charged with bigamy, which only statute states, whosoever being married shall marry any other person during the lifetime of the former husband or wife is guilty of an offence. The golden rule it tells the reader of the statute to read the wording in the context of the sentence as a whole and tries to assess what it was that Parliament was trying to say when writing it. The rules can be applied in two ways. Firstly, if there's any ambiguity of the meaning of the words of the statute, and secondly, it can be used to modify a word that has only a meaning in order to avoid any absurd outcome. The main advantage of using the golden rule is that drafting errors in statutes can be corrected immediately, and like this was seen in the case of R and Allen, 1872. Then we have the mischief rule, and this rule gives judges the most discretion of all, and the 4 principles to follow when expressed in the Hayden's case, 1584, which concerned a conflict over legal action against Hayden for trespassing on land, was firstly, there were 4 elements that in that case. Firstly, that what was the common law before the making of the act? Secondly, what was the mischief and defect for which the common law did not provide? Thirdly, that what remedy Parliament hath resolved and appointed to cure the disease of Commonwealth. And fourthly, that the true reason of the remedy, and then in the office of judge, is to make such construction as shall suppress the mischief and advance of the remedy. So this was a really important case in regards to the mischief rule. Is the case of Smith and Hughes, 1960, where the defendants were charged under the Streets Offences Act 1959 with soliciting in a public place. The prostitutes were soliciting from windows, technically not a public place. The mischief rule was applied to interpret that the prostitutes were doing what the statute was trying to abolish, so they were convicted. The mischief rule gives the most discretion to judges and suited to specific, often unambiguous cases. The rule allows statutes to be refined and developed. However, the increased role of judge means that his views and prejudices can influence the final decision. So now we're going to go on to look at the several types of different trusts, okay? So there are several types of trust, and most common is an express trust. Within this category, trusts are both fixed trusts and discretionary trusts. As we mentioned, a fixed trust is where the trustees have no choice as to who the beneficiaries are or how much they received. With a discretionary trust, they distribute the trust property as they see fit. However, they must distribute as they cannot keep it for themselves. For an express trust to be valid, there has to be 3 certainties: certainty of intention, certainty of subject matter, and certainty of objects. So the first one we're going to look at is certainty of intention. So the certainty of intention, the key established whether the requisite intention is present is to consider whether the creator of the trust wanted someone to be under a duty to hold property for the benefit of another person. The use of the word trust need not be present to show certainty of intention. However, when it is used, it may not show how certainty of intention depending on the context. The court will look at the substance of the creator's intent to see if they wanted to impose an obligation or request the trustees to do something. If it is merely a request, precatory words will be evident. For example, wishes, request, confident. The question of intention is assessed objectively, having regards to the opinion of the reasonable person. And the famous case in regards to that is the case of Lee Gulbenkian, 1970. So Gulbenkian settlement 1968, a significant English trust case where that delves into the issue of certainty within trust. The case importance lies in the interpretation of the appropriate trust for certainty in different types of trust, particularly distinguishing between mere powers and discretionary trust. Carlos Gulbenkian, a prominent businessman, established a settlement in 1929, outlining that trustees in their absolute discretion should allocate trust property to his son Nubo Gulbenkian and various associated individuals. The legal question arose here concerning the enforceability of the trust, primarily focusing on its alleged uncertainty. In the initial instance, Lord Chief Justice Gough declared that the settlement invalid, aligning with the precedent set in Gresham's settlement, where a similar clause was deemed invalid. However, the Court of Appeal took a different stance, deeming that the trust valid. Lord Denning emphasised the importance of practical applicability, arguing that a condition should be considered good if it possesses an intelligible and sustainable content, rejecting the idea of deeming a clause bad for uncertainty unless it rendered the clause meaningless. Lord Denning highlighted the trustees' particular practical application of clause without difficulty as a significant factor in validating it. Moving to the House of Lords, the is or is not test for powers of appointment was maintained, asserting that if an individual could be said to be or not in the class, the objects were sufficiently certain. Lord Upjohn, in reaffirming the list certainty test for discretionaries, acknowledged the court's duty to make sense of the ambiguous language. However, this decision set the stage for the subsequent developments in the understanding of certainty of trust. This case marked a transitional phase in the legal interpretation of certainties in trusts. The Court of Appeal's decision, with its emphasis on practical applicability and rejection of stringent certain requirements, challenged the established norms. This departure from strict adherence to the list certainty test contributed to the evolving landscape of trust law. The next one is looking at certainty of subject matter. So the certainty of subject matter is the requirement that the trust property left to the beneficiary must be easily identifiable along with the interest gained by the beneficiary. The trust is likely to fail if the property left on the trust is under-identifiable. So it's really important when you looked at certainty of subject matter that you identify that the property has been left for the individual. You're looking at that just, the certainty is properly expressed and it's properly defined as well, because it's so important when you look at the three certainties. You need to make sure that you're looking at the certainty of the subject matter and that everything has been declared. The subject matter test includes both the property subject to the trust and the beneficial entitlement of each beneficiary. For example, if a testor leaves all my shares in British Gas on trust for my 4 children equally, there is a certainty of subject matter because there is the certainty of property, so which is the shares in British Gas, and there's certainty of beneficial interest, which is each beneficiary is entitled to a quarter share. As well as property being identified, the trust must be able to be identified. And the leading case here was the case of Hunter and Moss, which was concerned with intangible property, and Re London Y, which was concerned with the operation of charters and passing of legal title. In the case of Re London Wine, a wine merchant here bought and held wine for clients for their order. The stock of the wine was held together without distinguishing which particular bottles were held for which client. The wine merchant company went into liquidation here, and the claimants argued that the wine they had ordered from the shipper was held on trust for them under the terms of their contracts. However, the creditors said it belonged to the company and was part of the company's assets in insolvency. It was held in court that this could not be a valid trust because the claimants could not identify which wine was held for them out of a general store. It would have been necessary for the claimant's wine to be segregated, that is, to be separately identifiable from the general stock of wine. So the principle in Hunter and Moss can be practically difficult as it's not possible to identify the rationale behind how the trust works in practice. If there's an absence of certainty of subject matter, the consequences will depend on the kind of uncertainty. So if the identity of the trust property is not certain, the trust cannot be attached to any property. Therefore, part of the trust is to be held on trust for beneficiary. So it's really difficult sometimes to identify when it comes to what is tangible and what is intangible. And when you're looking at the subject matter, so if in regards to tangible assets, if a settler created a trust on only part of their assets, for example, part of their wine collection, there's no certainty of subject matter unless the tangible assets are clearly identified, usually by segregating them from the larger stock, as demonstrated in the case of the London wine case. And if you look at intangible assets, that would be assets are treated differently, provided the assets are similar. So there's no need here for segregation. And that was the case of the earlier case we mentioned, the Hunter and Moss case, where the court had to decide whether the employer had the intention to create a trust, and so whether there was certainty of subject matter. The court held in that case that there was an intention to create a trust, as the shares were identical to each other. There was no need for segregation, and the employee was entitled to 50% shares. The next one is certainty of objects, and the objects of a trust will depend on the type of express trust in question. So the objects of a trust are its beneficiaries. This is what certainty of objects is. A trust without beneficiaries fails. Where there's more than one beneficiary, the class of beneficiaries must be ascertainable. The test to determine certainty of objects differs for fixed trusts as it does for discretionary trusts. So where a trust has more than one beneficiary, but the settler does not identify each and every beneficiary, but refers to, instead of class such as grandchildren or my employees, in a fixed trust, each beneficiary under the certainty of objects is entitled to specific share of the trusts. In a discretionary trust, the trustees have a discretion on whether or not to pay any member of a defined class of beneficiaries. The beneficiaries have no automatic right to payment, only the right to be considered by the trustees. (2.3) Analyze the impact of illegality on legal presumptions. So what is illegality of contract? Where a contract is illegal when formed, neither party will acquire rights under the contract, regardless of whether there was any intention to break the law. The contract will be void and treated as if it was never entered into. So types of illegality in contract law. Broadly speaking, courts will enforce a contract which is expressly or impliedly forbidden by statute. Example of an illegality found within a contract. So some other common examples of illegality include like contracts for the sale of distribution or controlled substances such as drugs or drug paraphernalia, agreements made by illegal activities which may include prostitution or gambling, and employment contracts that permit the hiring of underage workers. Statutory prohibition of contracts. So a contract may be prohibited by statute, either expressly or impliedly. And the important case in regards to that is the case of Mahmood and Isfania, 1921. I'll just go through some of the facts of that case. So in that case, under the Defence of the Realm Act 1914, order was made titled the Seeds, Oils and Fats Order 1919 that said a person shall not buy or sell or otherwise deal in linseed oil without a license. The claimant had a license to deal in linseed oil and sold 150 tons of the oil to the defendant. The defendant had incorrectly told the claimant that they had a license to deal in oil. In fact, they did not. Later, the defendant refused to accept delivery of the oil and the claimant sued for damages. The issue in this case was that the defendant argued that as he had no license to deal in oil, the contract was illegal under the 1919 order. Consequently, the contract should be illegal and void. Therefore, the claimant could not sue for damages upon it. The Court of Appeal held that the claimant could not sue upon the contract as it was illegal. Lord Justice Banks said that it is open to a party, however shabby it may appear to be, to say that the legislature has prohibited the contract and therefore it is a case in which the court will not lend its aid to the enforcement of the contract. Here, the order expressly prohibited the type of contract, so the parties had entered into. Therefore, to enforce this would undermine the purpose of the statute. Lord Justice Atkins said that a court could also infer a prohibition if the statute in question imposed a penalty upon someone entering into that particular contract. However, the terms of the statute would not have been examined very carefully. Implied prohibitions are much more difficult to identify, and there are two tests the courts may apply to determine whether the contract made is impliedly prohibited. The tests applied and the decisions made are very fact-dependent. Common law prohibition of contracts in regards to public policy. Contracts may be prohibited via the common law on the grounds of public policy or morality. There's a lot of uncertainty in this area, and when the court can prevent a contract from operating is often unclear. The court's approach to this area of law with consideration of the common law values of society. If the contract breaches common values of society, it will be void for common illegality. Lots of examples on contracts to commit crime was the first one of Biggers and Busted, which confirmed a contract which includes an obligation to commit a crime would be illegal. And this was furthermore identified in the case of Beresford and Royal Insurance. Contracts which prevent the administration of justice. Despite the law of contract, most is self-regulatory. In event of dispute, the courts will intervene. Contracts will preclude parties to the contracts accessing justice, or to prevent the courts interfering with a contract may be illegal on the ground that they prevent the administration of justice. And this was the case of Hayman and Hayman 1929, where the courts will not enforce contracts which frustrate acts of Parliament. The facts in this case was that Mr. Hayman was married to the respondent. He left her to live with another woman. Both he and the respondent executed a deed of separation in which he covenanted to pay his wife £2,000 alimony as well as weekly sum of £20 for her maintenance during her life. The wife in return covenanted not to petition any court for further alimony or maintenance other than the sums that had already been agreed. After divorcing her husband, she petitioned the court maintenance. At first instance, the court ordered that the deed did not prevent the wife from claiming maintenance. The husband appealed. The issue in this case was that the ex-husband argued that the respondent was still bound by her covenant in the deed of separation, not to petition in the court for permanent maintenance, even though they had divorced. He also argued that the public policy required that contracts should be kept and covenants honoured, and that he was simply keeping his ex-wife to her bargain. It was decided in this case, the decision was their lordships held that there was no provision in the covenant terminating it on the dissolution of the marriage. Therefore, it still operated. However, Lord Hailsham said that under the Judicial Act 1925, section 190, subsection 1, the court had discretion to make an order granting such sum of maintenance as it thought reasonable, and order payment of alimony that it thought just. The agreement indeed amounted to a covenant not to bring proceedings. This would have ousted the jurisdiction of the court to make such orders, and therefore it was illegal and invalid. Consequently, in this case, the Hayman case, the appeal was dismissed. Contracts which are sexually immoral. Sexually immoral contracts are those relating to contracts for sexual acts, as in the case of Pearson Brooks. However, this approach was evolved along with the society's view, which is the case of Sutton and Bishonde Ria, 2003. In this case, the plaintiff Sutton was a male prostitute. who entered into a sadomasochist relationship with DiL, a wealthy Swedish businessman. The plaintiff instructed the defendant's solicitors to draw up a cohabitation contract. The contract referred to a statement of trust which acknowledged that the master-slave relationship and stated the DiL would obey all the Sutton's commands and that all DiL's property belonged to Sutton, absolutely including all the monies in his bank. The solicitors advised the plaintiff that the agreement was probably unenforceable. The relationship ended when it discovered that Sutton was HIV positive and DiL required him to leave the property. Sutton found that the contract was indeed unenforceable. He then sued the solicitors. The issue in this case was that the plaintiff argued that solicitors were negligent for failing to draw an enforceable contract. The solicitors argued that any such contract was unenforceable as it was contrary to public policy. Lord Justice Hart held in this case that a property contract between two people who had sexual relationship and cohabited could be valid. However, the contract must not involve undue influence and the sexual relationship must involve no criminal act. There was no contract for payment for sexual services, which was illegal. This was apparent throughout the entire contract. There was a difference between a contract between two people who were in sexual relationship and an agreement that attempted to set out sexual relationship in property terms. The agreement sprang directly from the couple's master-slave sexual fantasies. Therefore, the agreement was unenforceable and the solicitors could not be sued in negligence. Contracts which involve public corruption. Some contracts are invalid because they involve corruption, such as the case of Parkinson College of Ambulance Limited, 1925. Common law prohibition of contracts, restraint of trade. To ensure there's continued freedom of contracts that restrain trade could be void for illegality, as the case of Nordenfelt. In assessing whether the restraint on trade is enforceable, the courts focus on whether the contract between the two parties is reasonable and if the limitation would not be in the public's interests. Is the contract reasonable? In the case of Herbert Morris and Saxelby, the courts identified general presumptions for deciding whether or not a contract may be illegal due to disproportionate restraint of trade, such as employment contracts that restrict former employees from being employed by competitors would normally be valid. Employment contracts that prevent the loss of trade secrets or stealing of custom would normally be valid, and terms in a contract for the sale of business preventing the seller setting up another business in the competition with the purchaser's business are normally valid. The effect of illegality. The case of Holman and Johnson is an authority case for the general principle of illegality, that the illegal contract will be unenforceable, dependent on the circumstances. One or none of the parties may enforce the contract, and on occasion, only party of the contract will be unenforceable. Severable illegal contracts, and the courts have the power to enforce a contract, but only where the legal parts of the contract have been removed. This is a three-part test to apply when attempted to sever parts of the contract. In the case of Sadler and Imperial Life Insurance Company of Canada Limited, 3 elements were identified: the blue pencil test, the remaining terms following the blue pencil test, and following the blue pencil rule, the contract must continue to be the same. So, collateral contracts, where there's one legal contract, but there's a collateral contract that allows the recovery of all part of the contract. This may be enforceable, but only if providing for remedy under the collateral contract is not equal to enforcing the illegal contract, as in the case of Fisher and Bridges, 1854. Claims on based on illegal contracts. And the general rule is that any claim based on illegal contract is invalid unless the claim is related to an unrelated part of the transaction of the contract, which the illegality does not affect, as in the case of Eurodyne Limited and Bathurst, 1990. In this case, the plaintiff's business involved the supply of precious stones at home and abroad. The plaintiff entered into a contract of indemnity insurance with the defendant in respect of export of a consignment of diamonds. The contract provided that the exporting should comply with the laws of the relevant country. Diamonds were exported to West Germany and stolen. The plaintiff brought an action against the defendant insurer claiming to be indemnified for the loss of diamonds under the contract of insurance. The issue in this case was that the defendants denied liability and claimed that the plaintiff had misrepresented the value of consignment so as to enable the German company to evade import tax, and therefore the plaintiff's claim was tainted with illegality. At first instance, it was held that there was no implied term, but the contract could be carried out in a lawful manner. Public policy did not require the plaintiffs be deprived of their claim. The decision of the court in this case was that the defendant appealed. The Court of Appeal held the invoice issued by the plaintiff constituted a criminal offence under the West German law. However, it was not issued for the plaintiff's own purposes and did not deceive the defendant because the true value of the diamonds was recorded on the plaintiff's register. The plaintiffs were not relying on the invoice in the instant action, and its issue could not affect the rights of the defendant. Accordingly, the illegality of the invoice was not such that public policy required that the contract between the parties should not be enforced. Recovery under illegal contracts. The final assessment to make when considering an illegal contract is whether or not any money or property may be recovered subject to the contract. Both parties are guilty. So when both parties are guilty in relation to illegal contract, the general rule from Holman and Johnson 1775 is that there can be no recovery of any kind of money or property. So that was one of the principles adopted in 1775 from that case. This rule has been challenged as being contrary to Article 1 of the Human Rights Act. No one shall be deprived of his possession except in the public interest. And it was dismissed in the case of Shan Shal al-Kishtani 2001. In this case, it was to do with the claimant's claim to recover money failed because of illegality. The claimant transferred 700,000 DM to the defendant in connection with a proposed business venture. Around $500,000 was returned by the defendant to the claimant, which represented the exact cost of the shares which the defendant agreed to buy. A dispute arose whether any money was still owed to the claimant as a result of the varying exchange rates. The issue that was identified in this case was at first instance, the court held that the defendant was in breach of trust by using the defendant's money for his own purposes. The transfer of funds to the claimant for the purpose of share allocation was not complete repayment, and the claimant was entitled to recover outstanding monies. On appeal, the defendant argued that the claimant should be prevented from recovering the monies as they had been advanced by him contrary to the Gold Securities Payments and Credits Republic of Iraq Directions 1990. The defendant submitted that such a bar to recover would be a breach of his right and under the Human Rights Act 1998. The decision and the outcome in the case is the Court of Appeal held that the trade embargo in 1990 directions applied to persons who were resident of Iraq at the time, and the directions came into force, which included the claimant. Therefore, the monies were irrecoverable on the basis of illegality. Furthermore, assuming that the claimant was actually entitled to invoke the right to property under the European Convention on Human Rights at all, the case clearly fell within the public interest exception to the right, and the illegality defence is not incompatible with the claimant's right to property in terms of the convention. One party unfairly induced into illegal contracts. So if both parties are guilty of entering an illegal contract, but one party has been forced into the contract as a result of duress or undue influence, the contract will be enforced, but the victim may successfully recover money on the property they have passed subject to the contract due to undue influence or duress, as that was seen in the case of Hughes and Liverpool Victoria Legal Friendly. And the link is there if you want to go and look at the case. One party withdraws from the contract. So if one party withdraws prior to the illegal part of the contract coming into effect, the doctrine of locus potiens comes into force. The result of this is that the party who withdrew may recover any money or property subject to the contract. The fact one party has withdrew will suffice, as in the case of Tribe and Tribe 1996, and the link is there if you want to go on to the case. There's been some debate as to when the withdrawal from the contract must occur, as in the case of Keeley and Thompson, 1890 is the correct approach. And then the withdrawal from the contract needs to be voluntary, as in the case of Biggers and Boustad, 1954. So we've finished learning outcome 2 now in regards to equity and trust unit, and these are the references that we've used in regards to that. So their links are there for you to go on to look at the references and refer to when doing your assignment or looking at learning outcome 2 on certain concepts. And also extra additional reading is also on Moodle for you to look at as well. So make sure you're going on to Moodle for any sort of additional reading. If you have any questions or anything, email learnerwork@ukvarsity.co.uk. We've now finished learning outcome 2. Please go on to Moodle for any additional readings, any journal articles, any ebooks, and some links are there for you to go on. So the next learning outcome we'll be doing is learning outcome 3. And thank you for attending today's session.